Welcome back, and right before the break we were talking about an example of an I-1 visa for a person who is a journalist, covers most of the Bollywood in India, and David was explaining that an appropriate visa is an I visa, and this person, if he meets all the qualifications, has a background, has the experience, as coming to the US to perform the similar duty, then he can apply for an I-1 visa. I just want to mention one thing about I-1 visas, then you can explain more details. There are many types of visas which need a petition to be filed. O petition, P petition, H petition, L petition. But my recollection is I visas, you don't need to file a petition. Just apply for the visa at the American consulate, give them all the documents, convince them that you are a journalist or getting into journalist activities, and I understand that to some extent even making documentaries are a part of journalism, because you cannot make a documentary unless you do that journalistic work, collecting all the data and information, and coming to the US to perform same or similar type of work.
Right. Okay, so actually I just want to clarify something, Michael, that you said, because I think our viewers might be just a little confused, because you said it doesn't require a petition, but it requires an application to the consulate.
Correct.
And what Michael is saying is that you don't have to file a petition here in the United States and then get the case approved by the USCIS and have it sent to the consulate where the individual goes to pick up the visa. Rather, you can make the application directly to the US consular office abroad, and that's the value. It's kind of like a B visa for a visitor.
Now, visitor visa or a student visa or a J visa.
Correct.
These types of visas, and I also, same thing.
Right.
These type of visas do not require filing of a petition with immigration, getting it approved before they can apply.
So it's an application directly to the consulate.
So what else can you tell about I visas?
The really nice thing about the I visa, which we like, there are pluses and minuses, of course, to all visas. And the key, of course, to anyone who is exploring their potential options with regard to visas and immigrating to the United States is make sure you know all of your options. Because this I visa holder, this individual who made the inquiry to us, also has other options available to them. And I would probably try to direct them into the pluses and minuses of each one. So the I visa, the thing I like about the I visa is it's DS, which means duration of status.
Similarly to F1. Or
similar to F1 or J1. And what's nice is that they don't go into SEVIS. So they're not, like, if they don't keep doing their program, they're not dropped from SEVIS, which automatically gets sent to ICE, where an individual from ICE goes out to have the person removed. So the I visa holder gets DS, duration of status, so there's no date certain on their I-94, which means that if they overstay, I'm not recommending anyone overstay, but if they overstay the date certain on the I-94, there is no date certain on the I-94, so there's nothing to overstay, which means that they can't accrue unlawful presence in the United States, which means that they potentially in the future don't have to worry about the 3- and 10-year bar. Now, that's the advantage of the I visa. The disadvantage of the I visa is that it's not a dual intent visa classification. So generally speaking, we don't recommend to our I visa holders that they should be pursuing the green card, because the underlying intent associated with pursuing the green card is, of course, that you intend to immigrate to the United States. If you do pursue the green card while you have an I visa, there's a conflict that's set up between the I visa and pursuing the green card. Now, however, and Michael properly pointed out before that you can do documentarians on an I visa. We prefer to do our documentarians on O1B visas, because O1Bs are artists, but they also take into account documentarians. And we've done many documentarians on the O1B. The nice thing about the O1B is that it's a dual intent visa. However, it is going to have a date certain. So unlike the value of the I visa, where there's no date certain, the O1B has a date certain. But all in all, what we tend to err on the side of the O1B as being a more valuable type of visa for an individual who might be a documentarian, whereas your Bollywood person, I think, would probably be more of an I visa type of person.
But also, I think that there are other always pros and cons, and some good and some bad thing, as you were trying to explain to the viewers. But one of the things that O1B may require is some kind of higher level or experience. But they are young journalists. Let us say that the journalist just came in a year ago or 2 years ago. He writes some articles for newspaper or something, may not reach the level of an O1B.
Well, actually, the fact that if the individual has written articles and has notoriety and is recognized in the field, that alone may be sufficient for him or her to get an O1B. Remember, an O1B is like an artist visa. So all you really have to do is prove that you're noticed in the field, and the O1B may be a sufficient type of visa. But these are visas that what I think Michael and I refer to as like, it has to pass the smell test. Whenever somebody sends us an email and says, I'd like to get an artist visa, or I'd like to do an O1B, I have an individual who might qualify, we always send out an email saying, please provide us with the resume, because we need to see the resume and we need to get a flavor for what the individual has done in the past to be able to assess the probability of whether or not an individual, or possibility of whether or not the individual may be able to get a visa in the O1B classification.
Can an I visa holder be self-employed? Actually, I think it's coming on behalf of somebody to cover the journalism.
Right. If an I visa holder is coming to the United States, they're usually going to be employed by the foreign media organization coming to the United States. Correct. However, we have done individuals who have been on contracts with media organizations, and I tend to find that the paparazzi work that way. So technically, they're not self-employed because they're under contract with the foreign organization, but there has to be a clear contract, and that contract also should specifically designate what the individual is going to be doing and where they're going to be doing it.
How about the period of time that they are sending?
There's really no designation as to the period of time. I think that the most important thing is that if an individual is going and making the application for the I visa at the U.S. consulate abroad, the most important thing is to have a good, solid itinerary. And if you have a good, solid itinerary, and that itinerary is backed up, of course, by events that are noticeable to the U.S. consular officer on the internet, that they can go and check to make sure that itinerary is valid, then everything should work out okay.
And should be able to overcome Section 214B, like the person
I was going to say 221G,
shouldn't have applied 221G, but 214B is straight denial if they have applied for immigrant visa before, or somebody has filed a petition for them for an immigrant visa. Question is raised. I'm not saying it's just a consular discretion. Let us say well-established journalist that clearly can establish that yes, his brother filed 10 years ago, 5 years ago, 3 years ago, but he's just going to cover a particular event. Still the consul believes that, he can still issue a visa. It doesn't prohibit the issuance of visa to him. But the question is raised. Question is raised if there's something on the record about his immigrant intent.
Exactly.
That's what it is.
So, and that is more likely to be raised in the context of an I visa, whereas with an O1B, you wouldn't have the possibility of a 214B denial. I mean, it's possible that you get one, but it's unlikely that you get a 214B denial because you have the possibility of utilizing the argument of dual intent.
How about a compensation? There's no salary here.
Well, it's kind of interesting. That's a great question, Michael, because a lot of times in the I visa classification, these are people, even paparazzi, that consider themselves to be, it's an art form. These individuals, go and take pictures. They have to kind of hide in the bushes and get pictures of the, of the various personalities. And so they're not really doing this job for money. They do it because there's a form of psychic remuneration that they're able to share their pictures with the public at large. So they're not really requirements for big numbers. In fact, we've done many paparazzi types of cases where the remuneration levels are extremely low.
So is it important that the person is living here, working here, eating here, financial support is needed? Is it important that all the support has to come from the employer or that contracting company, or can he use any income that he can make here pursuant to I think there may be a problem if he's making money here from people and doing the work or not.
Well, let me ask you, are you asking me a legal question or are you asking me a practical question?
No, here we are only talking legal questions.
Because the legal answer is that they're really only supposed to be making money on the contract that they have through the foreign organization. But some of the interesting ways in which it can be done is, let's say they come to the United States and it turns out that they're working, let's say they're working for TV Asia in India. And the individual comes to the United States, and then all of a sudden TV Asia in the United States says, we want you to cover this particular thing, we want you to do this. Well, what they can do obviously is they can channel the remuneration back through the Indian subsidiary, and if they do that, that's okay. There's not a problem, even though that technically they've been commissioned for a particular project in the United States. As long as it's channeled back through the Indian affiliate or subsidiary, I think that they wouldn't really have a problem.
हिंदी में बोलते हैं कहानी और होती है फसाना और होता है. That means the story is something and the song is something different, but there are always legal ways, not illegal, what you said
no,
is legal,
no, we say
ways of accomplishing the same objective.
Exactly. We call
by
it creative
using a
lawyering.
different alternative.
Exactly. We call it creative lawyering.
Correct.
And that's why, that's why you go to a lawyer, that's why you talk to an individual who's familiar with these types of cases and is able to ensure that whatever you're doing is in full compliance with what the immigration authorities, and when I say immigration authorities, I mean that broadly, also in terms of the consular officers, what they expect to see.
Well, it's time for a short break, and right after the break we're going to take some more issues or questions or topics that are very interesting. So stay tuned and we will be back.